Ok, on va commencer la commission droit.
We're going to be starting the committee meetings.
There is a case of inquiry when it comes to the migration situation and perhaps having something against Europe on this. Can you tell us a little bit about that? You said that it's not possible to have a case against a state or against Europe, but we have some people deciding not to help people in the Mediterranean Sea and causing a lot of dying people in this region. So I don't know what's the situation now at the ICP on this.
In June, there was a report as to the EU and its responsibility vis-à-vis our migration policy. You said that you would study the case. Are you going to be investigating EU officials vis-à-vis? Could you share what that procedure, how that procedure is moving forward? And are you actually going to give that priority?
And also regarding the migrants in Libya, the prosecutor of ICC, I think it's 2 years ago already, or 1 year ago, mentioned that the migrants in Libya also face crimes under international law, and they mentioned also the detention centers as slave markets. And I wonder what is happening at the moment in order to do investigations to see if authorities can be prosecuted. And what do you do with the complaints submitted by some lawyers to the ICC in order to ensure prosecution? This is also very important to the EU, as you know, that the EU is very involved in cooperation with the Libyan authorities on the issue of migrants.
As I explained before, and I've said that that issue is something that my office has been closely looking at, and something that we have also, under our strategic goal 6, that we have been trying to work with other states who are interested in having something done with respect to that. I confirm again that there has definitely been communication. We call it Article 15 communication that was sent to my office with respect to the migration issue, and also accusing several European states with respect to the fact that there are allegations of crimes regarding those who are trying to cross into the European Union from Libya. These are communications. It is received in my office. It forms part of the information that we receive, and it forms part of the assessment that my office will continue to do with respect to the situation in Libya. As I said, we continue to work in Libya. We are, again, trying as much as we can, given the challenging circumstances that we face in terms of security, the lack of resources, and all that. We are putting our best foot forward. We are putting all efforts to ensure that we have results in the situation in Libya. Again, the communication that was made is against states. And I remind again that our jurisdiction is individual criminal responsibility, not against states. But with respect to this communication, we continue to make the assessment in our situation analysis section, which, by the way, is now called the preliminary examinations section.
Nous avons maintenant le plaisir d'écouter les deux avocats qui sont les co-auteurs du dossier déposé en 2019 au bureau du procureur de la Cour pénale internationale sur la politique migratoire de l'Union européenne et particulièrement la situation en Libye. Le document qualifie de crimes contre l'humanité les politiques fondées sur la dissuasion menées par l'Union européenne après 2014 en matière de migration en Méditerranée. Je donne la parole à M. Omer Shatz, avocat international et maître de conférence en droit international en Sciences Po à Paris. Monsieur Shatz, vous avez la parole pour 4 minutes.
Merci. Good morning, everyone. Thank you for the invitation. So our case focused on individual responsibility as opposed to the failure of state responsibility, as Professor Moreno-Lax demonstrated. And the case submitted to the International Criminal Court is not about migration policies. It's not about human rights. It's not about states. It's about crimes committed by individuals against other individuals. Crimes that were planned, launched, and orchestrated in the institutional framing of the EU Commission, EU Council, and key member states. These crimes were directed not against another state, a terror organization, or even combatants, but against one of the most vulnerable populations in the world. Civilians seeking to flee an armed conflict, persons in need of protection from what the ICC Prosecutor described to the UN Security Council as a marketplace for human trafficking and numerous atrocious crimes under her jurisdiction. Human beings whom were targeted when they were in their most fragile moment of their life, when they were dying, in the course of drowning, when they could no longer breathe. Those who survived were forcibly transferred to what an European ambassador described as concentration camps. These people were subjected to a systematic and widespread attack that is still ongoing as we speak. The goal of this dehumanizing policy is to stem migration flows from Africa at all costs. At all costs, this precision, at all costs, is what transforms an institutional migration policy that can be legitimately debated into a criminal enterprise that must be prosecuted and investigated. The means to these deterrence-based policies are twofold. The first is killing by drowning. More than 20,000 children, women, and men were victims of the crimes against humanity of murder since 2014, resulting of the thoughtfully organized transition from Operation Mare Nostrum to Triton, the criminalization of NGOs, and the subsequent termination of any effective institutional search and rescue operations in the Mediterranean. The second is a policy of mass interception and forcible transfer to concentration camps-like facilities. The EU and its member states have carefully designed the general plan, created the required pseudo-legal and maritime framework, established the financial channels, provided the material means to and the training of their executants, and last but not least, by disclosing the location of migrant boats in distress at sea attempting to flee Libya, they handed over the would-be victims, the human resources, to the hand of militias and mercenaries. Under the Rome Statute, this second policy is responsible for crimes against humanity of deportation, imprisonment, enslavement, rape, torture, murder, and other inhumane acts against more than 50,000 victims who were intercepted at sea and forcibly transferred back to Libya since 2016. For the first time since World War II and the Holocaust, Western European officials, jointly with and through others, are implicated in uncontested crimes against humanity committed against tens of thousands of individual victims, turning the Mediterranean into a mass grave, the deadliest migratory route worldwide, the worst humanitarian crisis happening outside an armed conflict context. To execute this joint criminal enterprise, the EU and member states have not limited themselves to contracting with para-state armed groups. To legitimize and legalize this regime of mass violence, the EU and member states ensure to involve, to finance, and to gain the support of intergovernmental humanitarian and law enforcement entities, including the UNHCR, the IOM, and even the ICC, in an attempt to absolve themselves from criminal responsibility. This case is of fundamental importance to your institution, which is meant to control the executive branch of the European Union. It confronts you with historical responsibility. The budgets you approve, the resolution you adopt, will remain forever as evidence. Have you accepted the unacceptable? Are you capable to render justice to the tens of thousands of people whom have died because of people who look like us, like me, like you, speak like you, takes coffee with you? You have means and you must act. Adopt resolution, refuse to finance and defund the agencies involved in these criminal enterprises. Genuinely question those involved. Listen to victims' testimony and submit affidavits to the International Criminal Court. Raise awareness of what has happened and is still happening in the Mediterranean. It is not a humanitarian tragedy. It's not a divine fate. It is a European crimes against humanity. We count on you. Thank you.
Thank you, Omer. I give now the floor to Juan Branco, docteur en droit, qui a travaillé pour le procureur de la Cour pénale internationale et le ministre français des Affaires étrangères. Il est aujourd'hui avocat spécialisé en droit pénal international. Monsieur Branco, vous avez la parole pour 4 minutes. Merci.
Pero si Turquía los devolviera a sus países de origen, ahí sí que estarían en completo riesgo. Por tanto, yo creo que es un asunto muy delicado el del acuerdo con Turquía o el statement con Turquía, que requiere aproximarse con mucho cuidado, porque a partir de esas primeras informaciones equivocadas se han creado algunas leyendas urbanas que no reflejan exactamente lo que la Unión Europea acordó en aquel momento con Turquía. Gracias.
Muchas gracias, Nacho. Si je puis me permettre, je pense, et je laisserai la parole aux intervenants pour répondre, mais je pense que ce qui a été clairement évoqué par les intervenants, c'est de ne pas s'opposer à ce qu'il y ait des accords, mais que ces accords puissent être correctement encadrés avec des capacités légales d'intervenir à la fois pour les victimes, mais aussi pour l'Union européenne. Et donc, je pense que, mais elles auront la possibilité de répondre. Je vais donner la parole à Juan Branco. Si maintenant on a la capacité technique de l'avoir pour qu'il réponde déjà à des questions qui ont été posées. Et ensuite, je donnerai la parole aux autres intervenants pour 2 minutes maximum au niveau des réponses. Juan Branco, you have the floor.
Merci Madame la Présidente. Je vais m'exprimer en anglais. Crimes against humanity, these are not light words, nor a light accusation to throw at one of the strongest apparatus of power of the world in its parliamentary forum. Not a light accusation to throw in the very same scene where a month before, the all-powerful prosecutor of the ICC, Fatou Bensouda, found herself unable to address the issue, providing evasive and erroneous answers in order to avoid any confrontation. The stakes are high. Corpses lying in the sea that gave birth to our civilization. Tens of thousands of corpses abandoned to their fate. Corpses produced at an industrial scale by the same structures that are hosting us today. Is it why a prosecutor, 6 years after the beginning of the crimes and 1 year after our submission, has yet to pronounce a serious word on the matter? The burden is high, and it is of no ease to investigate the ICC's principal funders, best allies, and immediate neighbors. It is not an excuse, though, for lies. In this very scene, Ms. Bensouda falsely tried to argue that the case we respectfully submitted to her concerned state responsibility, insinuating that it was therefore not under her jurisdiction, regrettably counting on your unfamiliarity with the law to try to bring you to mistaken conclusions. I wish to stress this point. This is a grave lie, and manipulating the law in front of elected representatives not only insults the memory of the victims, but hinders the institutions and puts at stake the credibility of the prosecutor. Our case is not about state responsibility, and the prosecutor, as with any first-law student in international criminal law, perfectly knows so. This case is about the individual criminal responsibility that weighs over more than 100 persons that are currently being investigated by our legal team, 24 of whom were already mentioned in the brief submitted a year ago. Individuals that have been at the core of a machinery that has triggered the death and victimization of more than 50,000 people. We should not play games with the memory of these people. These people have been already invisibilized. We should not use the credibility our institutions provide us to manipulate the law. This case has been discussed all over the world, not only by scholars and experts, universities and media, but also in the most prestigious institutional scenes, from the German Bundestag to the Spanish Congress, passing by the UK House of Commons, and now the European Parliament. The Commission itself, through its spokesperson for migration, made an argument regarding the unintentional implication of its members in the commission of the crimes. Whether through lies or denial of their criminal responsibility, from the high representative of the EU to the ministries of Germany, France, and many others, reactions were numerous. None, including the most suspected ones, pretended that there was a jurisdiction issue. None accepted the sole person on whom relies the responsibility to investigate them, the sole whom should have taken the weight of such a decision, the prosecutor of the ICC. So I want to be clear once again. The criminal enterprise we have uncovered is well under the jurisdiction of the ICC. The dozens of politicians, bureaucrats, and civil servants of different European states and institutions whom were implicated in the crimes are all nationals of state members to the Rome Statute. In spite of the clear willingness, starting by Frontex, of many actors to erase all trace of their actions and omissions, thousands of pages have documented the meticulous organization of the systematic targeting of a particular group of civils defined as migrants, such only for the purpose of their victimization. From the General Directorates of the European Commission to the General Secretary of the Council, pacing by EAS and administrative bodies, Sherpas, ministries, and heads of EU member states, but also agencies like EMSA, Frontex, and so forth, it is individuals and not institutions whom have organized one of the most important deployment of bureaucratic and political means to achieve a political goal, stem migration flows at all costs, which became criminal exactly because it was pursued at all costs. Crimes against humanity. These words are not said lightly. They are the fruit of a 3 years investigation, but they are the sole legal conclusion we could land on after a long and rigorous odyssey through the complex and opaque EU procedures on the one hand, and the factual analysis of the consequences of EU policies in the Mediterranean and Libya on the other hand.
Juan,
I want to say, yes, just to conclude very quickly, that as we speak, we have launched the second phase of our work, which is to investigate and construct a comprehensive list of suspects in order to further establish individual criminal responsibilities over this dark period of our time. This should have been done by the prosecutor. In her absence, it has done by us.
Merci, Juan. On a bien entendu l'approche que vous soutenez. Je donne la parole maintenant aux autres intervenants s'ils veulent répondre aux questions concrètes qui ont été posées par les membres rapporteurs et shadow rapporteurs. Vous avez 2 minutes chacun pour répondre.
No problem. Thank you. I'll try to answer the questions made by MEP Strick and MEP Koster together because of the limited time. So the idea is that migration policies, any state is sovereign to decide on who to admit or not, and migration policies, again, is a legitimate topic for discussion. It ceases to be so, and it ceases to be a choice of what kind of policy to adopt when you reach the criminal boundaries of what we have outlined earlier. So the EU, the idea of doing something through others or jointly with others or outside state borders elsewhere, and for that purpose to be absorbed of your responsibility is simply a false idea. And the problem with the fact that we are the hearing like today continue to be to take place in the parliament years and years all over since the inception of the crisis is not because there is a migration crisis. There is, as MEP Koster stated, there is a human rights crisis. How EU Commission, EU Council, these kind of bodies are implicated in atrocity crimes, how we came to a place where maritime law is instrumentalized to reach migration ends, how we condition development budgets for controlling the movement of individuals. The answer is a failure of state responsibility. And the fact that state responsibility, whether through Strasbourg or whether through the tribunals of the EU, is failing to enforce the law, arrives to the point where we need to trigger individual responsibility. So to use now the example of MEP Strick, she asked, what is the enforcement mechanism of the Refugee Convention? So in the Refugee Convention, there is enforcement mechanism. It's the ICJ, the International Court of Justice. But since the conclusion of the convention in 1951, it was not triggered even once. There was no even one case triggered before the International Court of Justice to enforce the Refugee Convention. Why? Because this is interstate mechanism. It's a state-state mechanism. So the state will never have the incentive to enforce the Refugee Convention upon themselves. This is the same case. Thank you.
Thank you. Sorry. So if you want to say something more, we really receive your answer.